we have the crime of miscarriage, which is also being, I'm sorry that, no, he's taken my list. No, that I had listed them. In any case, the other questions are, that is 312. 312 is a crime which concerns miscarriage and causing miscarriage of a woman. And that is now being brought into a compoundable crime. I think this is absolutely unacceptable. You have the Medical Termination of Pregnancy Act, which is an act on its own. It gives a right to abortion for a woman, which we support the right to abortion, but at the same time, causing miscarriage, and to make causing miscarriage compoundable, I think that is not something which can be accepted. Then we have section 406. As everyone knows, 406 is more often than not used as criminal breach of trust, which is used in the retrieving dowry in cases where the dowry is not being returned to a woman who has been abandoned or deserted. And in many of those cases also 406 is used. So I would request, at present 406 is in table 2. I would request that status quo is maintained and this should not be shifted to table 1 where only the 2 parties can do it. Similarly, sir, these, the other important, very important amendments which I have moved refer to the issue of sexual harassment. Now, 354 is a very serious crime, and if you look at the rate of crime of the increase in this, in 2005 there were 34,000 cases registered, in 2006 there were 36,000 cases registered, in 2007 there were almost 39,000 cases registered, just below 39,000 cases. So this is a, thank you, this is a very serious crime, and therefore I feel to bring this crime, it is already there in table 2, but I would really request the Home Minister to delete it from the compoundable offences so that the seriousness of the crime can be recognized by society and action taken.
How much more time? How much more time?
I finished.
Because
I've just got
we have
one
to
more
take the other bill at 2 o'clock.
I finished. Then, as far as compensation is concerned, we have moved a bill. We have moved a draft which is before the Home Ministry, which concerns acid attacks on women and other attacks like that. And we have asked for a separate commission to be set up for compensation, both at the centre and in the state. In this amendment, what they have suggesting is that the District Legal Service Authority or the State Legal Service Authority should be the committee which can decide on the compensation. If it is possible, I mean, I don't expect the Home Minister to immediately respond now, but if he could consider this, that we require a separate committee to deal with this issue of compensation, because along with acid attacks, many courts are giving or suggesting that the state not give compensation, but for rehabilitation of different types of victims of violence among women, should also be given some kind of rehabilitation. So I think a separate committee, if it could be set up, that would be something which would be very helpful to women. Thank you, sir.
Thank you. Now that, will you?
I'll introduce the bill and then reply to this.
Oh, okay.
Or whichever way you want.
So introduce the bill and then you can reply to this.
Sir, I beg to move for leave to introduce a bill further to amend the Central Industrial Security Force Act 1968.
Bill introduced. Please.
Leave, sir?
Which one? No, which bill you?
First one, sir. First one is the
National Investigation.
No. The business shows CISF Act bill.
The question is that you be granted to introduce the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Bill is introduced.
Yes. Now, sir, can I reply to this debate?
Yes, 1 minute, the railway.
महोदय, मुझे रेल संपत्ति अधिनियम 1966 का और संशोधन करने के लिए एक विधेयक को पुरस्तापित करने की अनुमति दी जाए।
The question is that you be granted to introduce the bill. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, ayes have it, ayes have it. Introduce the bill.
महोदय, मैं विधेयक को पुरस्तापित करता हूँ।
And then,
Yes, sir, with your kind permission, on behalf of my colleague Shri Pavan Kumar Bansal, I beg to lay on the table of the House statement in Hindi and English showing the second batch of supplementary demands for grants general for the year 2008-2009.
will you introduce these two other bills also?
Sir,
National and
the next two is for consideration and passing. So
which
today,
one?
let me reply to this debate first.
The first,
सप्लीमेंट्री हमारा पहले हो चुका है।
वो हो गया है।
Introduce, that's
वो
all.
कुछ रिवर्स हुआ था, उसको रिवर्स कर लेना।
तो वो सब करेक्ट कर देते।
Sir, I'm grateful to the 7 honourable members who have participated in this debate on the amendment to the Criminal Procedure Code.
ये भी आया है।
So the outset, sir, I wish to say that this exercise has been gone through rather elaborately by the committee, and we have accepted many of the suggestions made by the committee. The Criminal Procedure Code is amended from time to time. I don't think there'll ever be a point of time where we can say that all the amendments required to be carried out in the code have been carried out and nothing more needs to be done. Because as we live and learn, the code has to be amended from time to time. Therefore, if there are some amendments which have not yet been proposed, some amendments of the committee which have not been accepted by the government, I would request honourable members to show some forbearance, because as time goes on, many of these amendments can be considered again in greater depth and accepted. Sir, these amendments which have been introduced today are based on suggestions made in the Law Commission in its 154th report, in its 177th report. These reports have been studied and examined in consultation with the state governments. The matter was examined by a group of officers, and then the bill was introduced in 2006 in the Rajya Sabha. I don't need to go into the various provisions which have been introduced. They are there before the House. An important feature of the bill relates to what is called victimology. Provisions are being made that the victim of a crime can also engage an advocate of his or her choice to assist in the investigation. A scheme is being formulated to provide compensation to victims of crimes. One of the most important features of the amending bill is the provision of protection to women. It has been proposed that all rape cases, as far as practicable, will be tried in the court of a woman judge. I take note of what honourable member said. It may not be possible to have a woman judge in every court where rape cases are tried. Therefore, the section says as far as practicable. The medical examination for arrested women will be done only by or under the supervision of a female medical practitioner. Investigation in cases of rape is to be conducted at the residence of the victim as far as practicable by a woman police officer. And all these provisions have been made. Granting frequent adjournments is a major cause of delay. I mean, belonging to that profession, I'm willing to plead guilty for that. Therefore, I think we have to put a lid on adjournments. Many, many years ago, when a criminal trial started, it cannot be interrupted. When PW1 goes into the box, until arguments commence, there can be no adjournment at all, period. Today we find PW1 examined by one judge, PW2 being examined by another judge 6 months later. That's hardly conducive to a fair trial of a criminal case. Therefore, I think the stricter provisions that we have introduced are correct, although Mr. Bhatia pointed out that it could work hardship. But I think some discipline is to come both in the engagement of lawyers and in the acceptance of briefs. Pendency in courts is also a major cause which has been engaging the attention of government. While other measures are being taken by the Law Ministry through this bill, some more offences are being made compoundable. I take note of what Mrs. Karata said, and I will, when she moves the amendment, respond to that appropriately. I've discussed the matter with her. Special provisions are being made through this bill for inquiry and trial of persons of unsound mind. They should also get a fair trial. Another issue that has caught the imagination of the people relates to video conferencing. And I was a little disappointed or maybe surprised that Mr. Bhatia should have opposed audio-video recordings. I think this has now come to stay. World over, audio-video recordings are routinely made, and I think we should also introduce this into our criminal justice system. So as I said, the bill was introduced on the 23rd of August 2006. Standing Committee submitted its report on 16th of August 2007. We have examined the suggestions. Many suggestions have been accepted. Some suggestions it has not been possible to accept. I regret that. But that doesn't mean the chapter is closed. We still have an open mind. We can examine that once again. And I think the amendments that are being made are amendments and steps in a positive direction, which will help make the Criminal Procedure Code more humane to law-abiding citizens, but more difficult for those who try to violate the law. With these words, sir, I commend the bill to this House and request that the bills be passed. There are a number of official amendments. In fact, there are more official amendments than private members' amendments, as a result of which many of the provisions originally introduced are being dropped. And as we come to them, I'll say which are the provisions being dropped, and the original provision of the CRPC is being restored. So much of the debate is really answered with official amendments. I request that the amendments be taken up, and I will respond to her amendments as she moves them.
The question is that the Code of Criminal Procedure Amendment Bill 2006 be taken into consideration. Those in favor, please say aye.
Aye.
Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Motion is adopted. We shall now take class by class consideration of bill. Class 2 stand part of the bill. There are 3 amendments, number 3 to 5. The Minister.
11, I know that. I know it's 11.
Minister to move the amendment 3 to 5.
Sir, I beg to move amendments 3 to 5.
Amendment moved. Those in favor, please say aye.
Aye.
Those against should please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendments are adopted. I shall now put class 2 as amended to vote. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 2 as amended is adopted. Class 3 stand part of the bill. There is one amendment number 6 by the Minister.
Sir, I beg to move amendment number 6.
Amendment moved. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Amendment is adopted. I shall now put class 3 as amended to vote. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 3 as amended is adopted. Class 4 stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, ayes have it. Class 4 is adopted. Class 5 stand part of the bill. There are 4 amendments, number 7 to 10.
Sir, I beg to move amendment 7 to 10 to clause 5.
Those in favor, please say, amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendments are adopted. I shall now put class 5 as amended to vote. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, ayes have it. Class 5 as amended is adopted. Class 6 stand part of the bill. There is one amendment number 11 by
Sir, I beg to move amendment number 11 to clause 6.
Amendment moved. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 6 as amended to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Class 6 as amended is adopted. Clause 7 stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 7 is adopted.
Sir, now, I beg to move amendments 12 and 13 to clause 8.
12 to 16.
12 to 16, sorry. 12 to 16 to clause 8.
Amendment moved. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Amendments are adopted. I shall now put clause 8 as amended to vote. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 8 as amended is adopted. Class 9, 10 and 10 stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 9 and 10 are adopted. Class 11 stand part of this. There is one amendment number 17.
Sir, I beg to move amendment number 17 to clause number 11.
Amendment moved. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 11 as amended to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Class 11 as amended is adopted.
Sir,
class 12 stand part of the bill. There are two amendments, 18 and 19.
I beg to move amendments number 18 and 19 to clause number 12.
Yes. Amendments moved. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. The amendments are adopted. I shall now put class 12 as amended to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Class 12 as amended is adopted. Class 13 stand part of the bill. There is one amendment number 20.
Sir, I beg to move amendment number 20 to clause 13. Oh, clause 13 is being deleted.
Amendments moved. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 13 as amended to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it. Class 13 as amended is adopted. Class 14 stand part of the bill. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it. Class 14 is adopted. Class 16 stand part of the bill. There is one amendment number 21.
Clause 15, I beg to move amendment number 21. The effect is clause 15 is being deleted.
Amendment moved. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put clause 15 as amended to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Clause 15 as amended is adopted. Clause 16 to 21 stand part of the bill. Those in favor, please say aye. Those against should please say no. I think ayes have it, ayes have it, ayes have it. Class 16 to 21 are adopted. Class 22 stand part of the bill.
No, sir,
class 22 by...
One amendment, sir. I beg to move amendment number 22 to clause 22. Effect is that clause is being deleted.
Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 22 as amended to vote. Those in favor will please say aye. Those against should please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 22 as amended is adopted. Class 23 stand part of the bill.
23 to clause 23.
There is one amendment number, class number 23.
I beg to move amendment number 23 to clause 23. The effect is clause 23 is deleted.
Those in favor please say aye. Those against will please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 23 as amended to vote. Those in favor please say aye. Those against will please say no. I think the ayes have it, the ayes have it, ayes have it. Class 23 as amended is adopted. Class 24 stand part of there is one amendment.
Amendment number 24 to clause 24. The effect is clause 24 is deleted.
Amendment moved. Those in favor please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put class 24 as amended to vote. Those in favor please say aye. Those against please say no. I think the ayes have it, the ayes have it, ayes have it. Class 24 is amended. Class 25 stand part of the bill.
I beg to move amendment number 25 to clause 25. Effect is clause 25 is deleted.
Amendment moved. Those in favor please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. The amendment is adopted. I shall now put class 25 as amended to vote. Those in favor please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Class 25 as amended is adopted. Class 26 stand part of the bill.
I beg to move amendment number 26 to clause 26. Effect is clause 26 is deleted.
Amendment moved. Those in favor please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. The amendment is adopted. I shall now put class 26 to as amended to vote. Those in favor please say aye. Those against should please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 26 as amended is adopted. Class 27 stand part of the bill. Those in favor please say aye. Those against should please say no. The ayes have it, the ayes have it, ayes have it. Class 27 is adopted. Class 28 stand part of the bill. There are two amendments number 27 and 28.
Sir, I beg to move amendments number 27 and 28 to clause 28.
Amendments moved. Those in favor please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendments are adopted. I shall now put clause 28 as amended to vote. Those in favor please say aye. Those against will please say no. I think the ayes have The ayes have it, the ayes have it, the ayes have it. Class 29 as amended is adopted.
I agree.
Class 29 stand part of this. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, the ayes have it. Class 29 is adopted. Class 30 stand part of the bill. There are 8 amendments.
No, that's all right. That's all right. He'll say that and then call them amendments.
There are 29 to 42.
So there are a number of amendments to class 30. So what I suggest is the official amendments maybe are from 29, 29.
29 and 42.
29 and 42. 42 will take later, sir. 29 you please call now, and then we will deal with Mrs.
The 29 and 42 we can take together.
Very well, sir. No, the 42 really is following Mrs.
No, but her is 35 to 40.
I know, but 42 will follow. No, you're 40. I'll explain. 42, sir, follows her amendment. Therefore, my request is please take 29 first. Then you can take 30 onwards. Then we'll come to 42. 29 you may take, sir. I beg to move amendment number 29 to clause 30.
Yes.
Yes.
I shall first put the amendment moved by Sri P. Chidambaram to vote. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, the ayes have it. Amendments is adopted.
Now, sir, if I may suggest, you got it as amended. Okay.
Yes.
No, sir, as amended won't come now. It will come later.
Now that after that will come.
Now you may kindly take up amendments number 35,
yes, 35 to 40.
One by one. I am accepting some and I am not accepting, but explain to her. Amendment number 35, in page 9, she wants that inclusion of section 324 as a compoundable offence to be deleted. I accept that amendment, therefore you can put that first to vote.
Which is the number?
Move the amendment. Amendment number 35.
Amendment number 30. I shall now put the amendment moved by Srimati Brinda Karet to vote.
Only 35, sir?
Yes. Amendment moved. Amendment number 35 moved by... Wait, there is lot... Don't confuse. There is a section. Please.
The section is
No.
clause 30. That is page 9, lines 29 and 30 be deleted. It concerns section 324.
I'll explain.
Which I just read out, but you were not in the house at the time of the debate.
Brinda, let me explain. Sir, under the present criminal procedure code, 323 and 334 are compoundable in table 1. 324 is not compoundable. We are introducing 324 as compoundable. A case has been made that 324 should not be made compoundable because 324 is an offence where voluntarily causing hurt by dangerous weapons or means. I accept Mrs. Karat's case. 324 should not be compoundable. Therefore, the amendment may be accepted.
That is, I shall now put amendment number 35.
Yes.
Moved by Srimati Brinda Karet to vote.
Yes.
Those in favor will say aye. Aye. Those against should please say no. I think the ayes have it, the amendment is adopted.
Yes.
Sir,
Yes, next also I accept. You move it.
Sir, I move that in clause 30, page 10, lines 5 to 7 be deleted.
Sir, if I may respond. This relates to section 406, criminal breach of trust. It is now in table 2. It is being brought into table 1. She says, let it remain in table 2. I accept it. Let it remain in table 2. You may take it out of table.
Thank you, sir. I am very grateful
That
to the
will be
minister.
number 30?
36, sir.
36.
Sir, in amendment, are you putting it to vote?
No, yes.
Yeah, he's putting it through.
I shall now... Amendment moved.
Sir,
No.
Sir,
Yes,
the
he has moved
amendment
it.
is moved, but since the minister has said that he is going to keep the status quo,
No, Brinda, you move this amendment, it has to be first
I
taken
moved
out.
it.
Just move it, I'll tell you how.
Okay, I move the
I'll
amendment that in
move
page
later
10,
for
lines
inclusion.
5 to 7 be deleted.
Now, I shall now put amendment number 36 moved by Srimati Brinda Karat to vote. Those in favor, please say aye. Yes. Those against, please say no. I think the ayes have it, amendment is adopted.
Yes.
Sir, in view of the Minister's official amendment
Yes.
on this clause, I do not want to push
Press
for this
37.
amendment.
37 is not
For
pressed.
37, I don't want, because he's
37
already
to
accepted
40,
it.
37
No,
to 40.
37 is not pressed, that's all.
37, I'm not pressing.
37 is
Sir,
not
I
pressed.
press for 38.
37 is not pressed.
Yes.
Sir, 38, that at page 12, lines 7 and 8 be deleted. This relates to section 312, that is causing miscarriage to a woman. I have already moved that amendment, and in my speech I explained it.
Sir,
I moved that amendment.
Now, I'm unable to accept this amendment for the following reason. 312 is about causing miscarriage, and 312, if I may read 312 of the IPC. Causing miscarriage, whoever causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith, be punished. Then 313 is causing miscarriage without woman's consent. Whoever commits the offence defined in the last preceding section shall be punished if it is done without the woman's consent. Then 314 provides for with women's consent. The problem about miscarriage is it can happen in a variety of ways, and I'm told it's difficult to pinpoint whether the miscarriage was a natural miscarriage or a miscarriage deliberately caused. Therefore, the recommendation is that if a miscarriage has been caused under 312, if the woman consents, it can be compounded with the permission of the court, because this occurs in table 2, not in table 1. Therefore, first you must have the consent of the woman, and secondly, it must be with the permission of the court. I think arguments can be made on both sides, but I would appeal to Mrs. Karat that since it is in table 2, it has to be with the consent of the woman, and it is with the permission of the court. Let it remain as it is, as we have introduced by way of amendment.
Sir, I withdraw my amendment.
38 is not pressed.
Yes.
Now, on 354, sir, I press to move that
Yes.
amendment, that at page
Yes.
12, lines 18 and 19 be
Yes.
deleted.
I accept your amendment. You may kindly put 39 to vote. I accept the amendment.
Sir,
I shall
I'm
now
really
put
very
amendment
grateful.
moved by
You are a much
Srimati,
better Home
amendment
Minister
number
than you were as
39,
a finance
moved by
minister.
Srimati.
But
So I
she's-
have to
sir,
congratulate him.
I don't know whether I'm a much better home minister. She's
Then
more
you are not
reasonable.
a finance
She's more
minister.
reasonable talking about criminal law than financial matters.
Now,
Today was Mr. Sitaram's turn to give backhanded compliment.
now 39.
Move
So I
39.
move
Brinda.
that at page 12, lines 18 and 19 be deleted.
I shall now put amendment number 39 moved by Srimati Brinda Karat to vote. Those in favor, please say aye.
Aye.
Those
Aye.
against will please say no. The ayes have it, the ayes have it, ayes have it, the amendments are adopted.
40 you're not pressing.
Sir, I'm not pressing. for the
Amendment
next
number
amendment.
40 is not pressing.
No.
The House have the permission to withdraw.
Yes, yes. 41. I'll
Now
explain.
40,
So 41.
So 41 I've made, if you can.
41, sir, the District Legal Services Authority and the State Legal Services Authority have a woman member. Therefore, let us leave it there at that and we'll see later.
so you are withdrawing.
Yes.
Amendment number 41 is not pressed.
42 I'm moving, sir. I've
Yes.
given notice of amendment 42
Yes.
to restore 406 to table 2. 42 I'm moving.
I shall put amendment number 42. You are moving, na?
Yes, sir, I'm moving. 42.
Amendment 42 moved to vote. Those in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it, amendment is adopted. I shall now put class 30 as amended to vote. Those in favor, please say aye.
Aye.
Those against will please say no. I think the
Well,
ayes have it,
nobody's
the ayes
saying
have it,
that.
ayes have it, class 30 as amended is adopted. Class 31 stand part of the bill. Those in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it, the ayes have it, ayes have it, class 31 is adopted. Class 32 stand part of the bill, there is one amendment number 30 wise.
Clause 30, yes, sir. Clause,
32.
yes. Sir, I beg to move amendment number 30 to clause 32.
Amendment moved. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, ayes have it, amendment is adopted. I shall now put clause 32 as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 32 as amended is adopted.
Sir, I beg to move amendment 31 and 32 to clause 33.
Yes. Clause 33 stand for the bill. 31 amendment moved. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Amendments are adopted. I shall now put clause 33 as amended to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 33 as amended is adopted. Clause 34 stand part of the bill. Those in favor, please say aye. Those against should please say no. I think the ayes have it, the ayes have it, ayes have it. Clause 34 is adopted. Clause 35 stand part of the bill. There is one amendment number 33.
I beg to move amendment number 33 to clause 35. Effective clause 35 stands deleted.
Amendment moved. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Amendment is adopted. I shall now put clause 35 as amended to vote. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, ayes have it. Clause 35 as amended is adopted. Clause 36 stand part of bill. There is one amendment number 34.
Sir, I beg to move amendment number 34 to clause 36. The effect is clause 36 stands deleted.
Amendment moved. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put clause 36 as amended to vote. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, ayes have it. Clause 36 as amended to vote. Clause 37 stand part of bill. There is one amendment number 41 by Srimati Brinda Karat.
No,
that you have it.
Not pressing.
Clause 1 stand part of the bill. There is one amendment number 2 by.
No, sir. 37 to 41 you must put to vote.
No, this is
38 to 41. Clauses.
38. That is over.
38 to 41 is over. Sir.
Over.
Clause 1.
The enacting formulas.
No, sir. Clause 1 there is.
No, 1 minute. Clause 1 stand part of the bill. There is one amendment.
I beg to move amendment number 2 to clause 1 to substitute the word 2006 by 2000, figure 2006 by 2008.
Amendment moved. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put clause 1 as amended to vote. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, ayes have it. The clause 1 as amended is adopted. The enacting formula stand part of the bill. There is one amendment
Sir,
number 1.
I beg to move amendment number 1 to the enacting formula.
Amendment moved. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, ayes have it. Amendment is adopted. I shall now put the enacting formula as amended to vote. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, the ayes have it. The enacting formula as amended is adopted. The title stand part of the bill. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, the ayes have it, the ayes have it. Title is adopted.
Sir, I beg to move that the bill as amended be adopted.
Motion moved that the bill as amended be passed. The question is that bill as amended be passed. Those in favor, please say aye. Those against, will please say no. I think the ayes have it, ayes have it, ayes have it. Bill is as amended is passed.
Good.
Honorable members, I have to inform the members that the Business Advisory Committee in its meeting held on today, the 18th December 2008, has allotted time for government legislative business as follows. Consideration and passing of following bills. Information Technology Amendment Bill 2006, 2 hours. National Investigation Agency Bill 2008 as passed by Lok Sabha. The Unlawful Activities Prevention Amendment Bill 2000 as passed by Lok Sabha. 6 hours to be discussed together. Consideration return of the following bills after are passed by Lok Sabha. Appropriation bill relating to demand for grant general second batch for year 2008-2009 1 hour. Appropriation bill relating to demand for grants railway second batch for 2008-2009 2 hours. The committee also recommended in view of the heavy legislative business on Friday the 19th December 2008 only introduction of private members bill will be taken up.
NIA bill is
This bills you can move the bills. The National Investigation Agency and Unlawful. Bill has to be.
I've got NIA.
CSF हो गया ना? ये हो गया. This is also bill.
Sir, the National Investigation Agency Bill and the Unlawful Activities Prevention Amendment Bill have been adopted by the Lok Sabha with some amendments, and the bills as amended by the Lok Sabha are before this House. So I may say with a deep sense of gratitude that the Lok Sabha adopted these bills unanimously. There was one amendment which was voted out, but otherwise the bills were adopted unanimously. And the reason is that in our consultation with the major political formations in Parliament, they have extended support to the idea and to the content of the bills. So I know that there are sections which have reservations to one or two aspects of the bill. These reservations, I believe, are genuine reservations, genuine concerns, and I think in course of time, when this law is applied and worked, we will know whether the law is working well or whether these reservations deserve to be addressed. The NIA bill itself is a very simple bill. It sets up the National Investigating Agency. There are only 8 acts in the schedule in respect to which the agency has powers. The first information will be registered in the police station and then forwarded to the state government. The state government shall forthwith forward it to the central government. The central government may, having regard to the gravity of the offence and other relevant factors, direct that the case be taken up with the NIA. Otherwise, the case remains with the state agency. Even if the NIA takes up the case, there is a provision which says, if it is expedient to do so, it may associate the state agency with the investigation. There is also a provision which says, if after some time it feels that the case can be returned to the state for investigation, the NIA may return the case to the state for investigation. There is a provision for setting up a special court. We have said the Chief Justice will nominate the special judge and the case shall be tried on a day-to-day basis. The superannuation of the judge shall not interrupt the trial. In fact, he can be allowed to continue until the trial is complete or until a specified date. And with these, sir, I think it is felt necessity of our time that there should be a national investigating agency, and I hope that the entire House will support the establishment of the NIA to investigate these offences. Appeals against the orders of the special court will lie to a division bench of the High Court, and the appeal shall be disposed of within 3 months. Sir, the other bill, the Unlawful Activities Prevention Amendment Bill, is, if I may say, an attempt to balance 2 conflicting interests, apparently conflicting interests. The one interest is that the state must be armed with strong laws. The investigating agency must have powers. The prosecution must be confident that if it marshals the evidence and places before the court, it can secure a conviction of the accused. That is one interest of the state, one interest of the people. The other interest is that human rights are fundamental and basic. Fair procedure and to be tried fairly is part of personal liberty. That no man's personal liberty can be taken away except according to procedure established by law, which is simply not a mechanical procedure, but is substantive due process. Therefore, balancing the interests of strong anti-terror laws and the need to protect the fundamental human rights of persons, including the accused, we have drafted this bill, and I'm sure the members who speak and the Minister, Mr. Ashwini Kumar, would intervene. Minister, Mr. Kapil Sibal will intervene if necessary. They will explain the provisions of the bill, but broadly what we are doing is imposing restrictions on the power to grant bail, applying the provision of drawing a rebuttable presumption in certain cases, and requiring that before prosecution is actually sanctioned, the executive government must take the recommendation of an independent authority who will review the evidence. So we are strengthening the law, at the same time providing safeguards. While closing the debate, I shall reply at greater detail if necessary. The provisions are self-explanatory, and I'm sure all honourable members have read the bill. I request that both bills be passed as adopted by the Lok Sabha. I would only conclude by saying it's important that we show unity of purpose and unity in action. There is no better way to demonstrate this unity than to unanimously vote in favor of these bills. Please express your reservations. Please express your concerns. We will deal with those reservations and concerns to the best of our ability. We will revisit the provisions if necessary when we meet again in February. But for today, let the House unanimously approve these two bills as passed by the Lok Sabha. With these words, sir, I commend these bills and ask the House to consider and vote upon them.
Sri Arun Jaitley.
I'll have to go in a little while.
Mr. Deputy Chairman, sir.
Narayan Swami.
I am extremely grateful to you, sir, to permit me to speak on these two bills. The first seeking to create a national investigative agency, and the second bill amending further certain provisions of the Unlawful Activities Act. Sir, I must confess that I speak with a mixed feeling. The mixed feeling is that my party and others who support us could derive at some stage some sense of satisfaction that at least in some areas, if not all, what we have been very strenuously saying for the last 4 years and 7 months, that a strong legal mechanism is also required to investigate and punish terrorism. The reason and the rationale that we have set out for this, at least a large part of what we have said is now being finally accepted by the government. We might even get some satisfaction from the fact that most of the arguments which were used to repeal the erstwhile anti-terror law, POTA, are now proving to be spurious. We can also get satisfaction as a country from the fact that there is a near unanimity, both in the country outside as well as in this House, as also in the Lok Sabha, that these two legislations are required. But we are at the same time concerned about the fact that the measures which government have taken are still not strong enough and still fall short in a large measure as a legal mechanism for fighting terror. Sir, we are also concerned, and I am sure every Indian is concerned about the fact that what has brought this consensus is not really the sound and strong logic that we have been giving to this government for more than 4.5 years now. Where reasoning failed, where our rationale failed, I think the 10 evil men who entered Mumbai on 26/11 and shook the conscience of this whole country succeeded in persuading the Indian society that India can no longer afford to be a soft state and must finally start adopting hard measures if it is really serious about combating and fighting terrorism. Sir, I remember that there were different reasonings given why India did not need a strong anti-terror law. When POTA was repealed, I was looking back at the debates, and even when it was first introduced, I was reading the debates. The country was repeatedly told by the opponents of a strong anti-terror law that a strong anti-terror law is not per se against terrorism, it is against minorities. The country was then told that normal laws in India are enough to tackle terror, and when you have so many normal laws, why do you need a special law to tackle terror? The third reasoning made out was that a special anti-terror law per se would be opposed to the constitutional guarantees and human rights. And as a Republican constitution, we can't afford to have a strong anti-terror law. We were then told that there is a huge scope for misuse and abuse of this law. And since there is a scope for misuse and abuse of this law, it's much better to go by the normal laws and not have this law. And lastly, sir, an argument was repeatedly raised, and I have seen a large number of my friends raising this argument only till the other day, in and out of this house. But anti-terror laws don't prevent terrorism. Despite Pota, an attack could take place on Akshardham or it could take place on Parliament. And since despite an anti-terror law, attacks can still take place by terrorists, what's the point in having a special anti-terror law? Sir, I repeat that the 10 evil men who entered Mumbai on 26th November have shaken all these fundamental assumptions on basis of which a strong anti-terror law was being opposed. And today, with the kind of measures which have been announced, plus some additional measures which have still not been taken by this government in this law, it appears that the government now also believes that all these assumptions which were being given to oppose a strong anti-terror law were really spurious assumptions, they were fallacious assumptions. Sir, it is obvious to anybody who understands how a fight against terror and insurgency can take place that a battle against terrorism is not fought in the courts of law. Terrorism is not something that can only be fought through legislation. An anti-terror law is never a substitute for a strong preventive intelligence. An anti-terror law is never a substitute for a strong security action and a quick reaction commando action against terrorism itself. To fight terror, you need a large number of steps. If it's cross-border terrorism, if it's internationally engineered terrorism, you perhaps need a global consensus. You may even take foreign policy initiatives and work for a global consensus for sanctions against countries and states which encourage terrorism. You require a very strong intelligence network to fight terrorism. Not only within your own country, you require a strong intelligence network which infiltrates into the enemy camp and pre-warns you of what is likely to happen. And then you require that intelligence to be shared with those who require that adequate intelligence information and the follow-up action to be taken, which at times we find we are lacking in not taking that. What we do as a security response, our lasers, is not relevant. Our quick security responses, our immediate security responses really determine, because if we take action after hours, the terrorists have already won. They've created a global impact, they've created a national impact, and therefore these are essentials which are required to fight terrorism. An anti-terror law or a machinery to investigate terrorism, whether it's a central agency or a state agency, comes into the picture not as an agency or a law which can prevent acts of terrorism. It's not an agency which can really start distributing intelligence all over the country. It's not an agency which will per se have a security force at its disposal to prevent terrorism. That has to be done by the various agencies which are earmarked for this purpose. The law and the agency comes into the picture either just about when an act is being planned or when an act has just been committed. and therefore for the purposes of collection of evidence, investigation of that crime, punishment of the criminal, you need a law and you need an agency which is effective. You need a law which can adequately collect that evidence, which can bring out that evidence and put it at the disposal of the prosecuting agencies, and then the conviction of those involved in acts of terrorism becomes simpler and easier, so that your conviction rate goes up. And when your conviction rate in terrorist offenses goes up, it's a deterrent for those who commit act of terrorism not to indulge in their acts. The preventive impact of this law is, it reflects the determination of the government and the Indian state in fighting terrorism. And the Indian state then is adequately equipped in terms of law to investigate the crime and expeditiously punish those who are responsible for that crime. As I said, the battle against terror is never fought exclusively in courts or through a legislation. You have first to equip the minds of the government and the agencies of the government. It's in the hearts and minds of the people of India that they must get ready that we are a state which is on the terrorist radar, and therefore we must equip ourselves to fight terror. It is through these acts that the determination of the Indian state in fighting terror is expressed. Unfortunately, 95% of the tenure of this government is over. And that 95% of the tenure of the government is spent in convincing each one of us why a strong anti-terror law was not required. And different arguments, as I have already explained, were taken out to establish that these are not essentials which are required, and an effort was being made. And I am afraid, even though the Home Minister's bill indicates to the contrary, what some of his colleagues have been saying still indicates, and that's what we are concerned about, that the battle against terrorism is to be diluted because you think the battle may prove to be politically costly, and therefore the vote bank signal which has to be given is to the contrary. Well, I don't think it's a matter where any one of us can really be amused, because the argument really is that when you have both houses of parliament debating on this bill, at the same time you have a colleague of the Home Minister making a statement yesterday which is flashed on all front page newspapers of our western neighbor. The blogs coming out of Pakistan are full of it. Look, we always said so. Now that's a signal which I am referring to, and that's the signal which your government spent 95% of its recent tenure in giving, rather than in taking substantive steps in fighting terrorism. Sir, even though we found some aspects of this law to be inadequate, my party had announced very categorically that we would support these bills. Even though we said that these are half a step, we would support a half a step against terror, but continue to campaign for the other half, the seriousness of which the government may not have realized. I am conscious of the fact from what the newspapers report that the Home Minister can't really be blamed for it, because the newspapers, at least if they are to be believed, did indicate that he tries to bet his best to get some more provisions. But some of his colleagues were perhaps concerned with forthcoming elections rather than the security considerations which were inbuilt in those suggestions.
Unfortunately, our newspapers sometimes report wrongly. The bill that was brought by my ministry, by me, to the cabinet is exactly the same version that was introduced in the Lok Sabha. Nothing was added, nothing was deleted. The cabinet unanimously approved the draft that I brought.
See, unfortunately, we have a cabinet which has too many spokesmen, and therefore, each ally of this government, each ally of the government seems to be taking credit for diluting this bill. Sir, I'm glad that the Home Minister has clarified this, because then I would like to withdraw the little compliment that I gave him, where I thought that at least he had realized the seriousness and the gravity of the situation and tried to bring in something which he honestly admits that he did not bring in. So in order, therefore, my primary task would be to convince him so that he can convince his colleagues as to what further is required to be done as far as these laws are concerned. So in order to just simplify the issue, let us for a moment, before I go into the abstract of what is required and what is already there, just discuss and place before this House that what is it essential which is required in the investigation of a terrorist offense. A terrorist offense per se is not like an ordinary crime where eyewitnesses would be easily available. A terrorist offense per se will have conspiracies at times which are hatched in foreign soil. You'll have some people, the Fidain, the jihadi terrorists, the suicide squads, who are not scared of dying, who are not scared of the prohibitions contained in the law, who are not even scared of the consequences of the law. And therefore you will always have a larger conspiracy behind the apparent terrorist acts. We can analyze any one of the terrorist cases which have recently taken place. Let me just point out a glaring terrorist case recently took place in Mumbai on 26th of November. On the surface, 10 terrorists came by the sea route, attacked various vital places in Mumbai. 9 out of the 10 are killed, 1 is arrested. What happened in Mumbai is extremely easy for Indian police to prove. You have eyewitnesses. You'll have various other evidences. You'll have reports of experts. And it won't be a difficult task for an Indian investigative agency to prove it against those 10. But 9 out of the 10 are unfortunately not there. It's a rare case that a terrorist has been caught alive. Ordinarily, they are not caught alive. But the real conspiracy is not merely those 10. The real conspiracy in this case is, and that's where your law is lacking, who were the people who trained these 10 across the border? There were obviously some training camps where for a year, year and a half, these people were given extensive training. Funds were made available to them. Their families were assured that monies would be given to their families in case anything happened to them. Weapons and equipment was supplied to them. RDX was supplied to them. It is possible that such an operation could not have been carried out without the support of the official agencies. Who were these people who organized the entire conspiracy across the border? Pakistan is living in denial. Their High Commissioner made a statement yesterday, their Foreign Minister made a statement yesterday that Masood Azhar is not in Pakistan, conflicting what had been said earlier. Pakistan as a state which is living in denial will continue to deny. Pakistan doesn't seem to be in a mood to render cooperation. And therefore the responsibility is ours, the onus is on us to prove the Pakistan link and the Karachi limb of this conspiracy. Now the terrorist who has been caught alive is speaking. His statements are being published. And his statements are being shared with the entire world. But under this law, with adequate safeguards, and I underline and re-emphasize the word adequate safeguards, if Kasab's statements to the investigating agencies are not evidence, then we may well be reading just a news in a newspaper which is not evidence in a court of law. And Pakistan would then turn around and say, what Kasab is saying is not evidence under your own law in your own country. How do you on the international forum make it as an evidence against me? Let's move a little backwards. One of the most glaring cases in India, the late Shri Rajiv Gandhi was assassinated. When Shri Rajiv Gandhi was assassinated, TADA was in force. Though eventually the Supreme Court did not convict them under TADA because of some interpretation of the definition of TADA, but the Supreme Court still applied the rules of evidence of TADA. The human bomb, the lady with a human bomb killed Rajiv Gandhi on spot. The actual killer died on the spot. 50,000 people witnessed that killing. And yet when the matter came to court, our SIT went to the first conspirator, those who supplied the vehicles, those who supplied the arms, those who supplied the shelter, those who harbored them, those who planned the conspiracy. Our SIT got all of them. The SIT did a remarkable job in reconstructing the whole crime. And finally the SIT found, just as we don't have any eyewitnesses of what happened in Karachi or the terrorist training camps, the SIT did not have any eyewitnesses of what the conspirators were doing behind closed doors. Conspiracies are hatched in darkness. They are behind closed doors. They don't leave eyewitnesses behind. So it's only when the first conspirator sang, the second conspirator spoke, that their evidence under TADA became admissible evidence, and the conviction of the other accused in the Rajiv Gandhi assassination case took place only because of the admissibility of those confessions. Take those confessions out and this country would have been a laughing stock, where a former prime minister is assassinated in front of 50,000 people and you wouldn't have had a conviction in the case. The actual assassins had died on spot. Take the parliament attack case. The 5 actual persons who attacked Indian parliament died within this premises itself. It's the conspirators who were arrested. And the most material evidence against the conspirators is a lot of what some of them, the first man and the second man who were arrested, those who spoke. Now it's always been said, and this is not only in this case, and I'll come to it a little later, what is it which is required in a strong anti-terror law? And I always tell my friends in the government, when India